Welcome to this Missouri Bar CLE on expanded remote access to CaseNet. This seminar presentation will have 4 presenters today. My name is Jeff Bates. I'm a judge on the Missouri Court of Appeals Southern District. And to my right is Kathy Zacharias. Kathy, please introduce yourself.
Hi, I'm Kathy Zacharias. I'm legal counsel with the Office of State Courts Administrator.
To my left is Melinda Bentley. Please introduce yourself.
Hi, I'm Melinda Bentley. I am your legal ethics counsel here in Jefferson City, Missouri.
And then our last panelist is David Ranson. Please introduce yourself.
I'm David Ranson, a trial lawyer with Ranson Injury Law in Springfield, Missouri.
What our CLE presentation today will cover, the first major topic is technical considerations. Kathy is going to present the first portion of that. I will do the second portion of that. Then Melinda will address ethical considerations, and then David will talk about practical considerations. And so with that, we're ready to turn the presentation over to Kathy.
I'm Kathy Zacharias, and I'm going to address the technical considerations of the rule. You can find the rules on the Supreme Court's website at courts.mo.gov, and you'll need to click on the rules and resources at the top right. Court Operating Rule 2 is the rule on public access to records, and that can be found under the Court Operating Rules after you click on the rules and resources. We're going to be addressing changes in Court Operating Rule 2 as addition to Supreme Court rule changes. Under Court Operating Rule 2.02a, the general policy regarding access to records is that records of all courts are presumed to be open to any member of the public for purposes of inspection or copying. As all good rules, there are exceptions to the general policy. According to Court Operating Rule 2.02a, the general policy does not apply to records that are confidential pursuant to statute, court rule, or order, or other law. It does not apply to judicial or judicial staff work product, internal electronic mail, memorandum or drafts, or appellate judicial case assignments. The remainder of the program will only focus on records that are considered confidential and not the last 4 bullet points. The first thing to recognize is that the rule is prospective in nature and not retrospective. The goal for implementation and the rollout was that lawyers and other filers would not have to do anything to the documents that have been previously filed with the courts. All documents that are filed before July 1st, 2023 will not be remotely available to the public, even if the case existed before the effective date. Documents that can be found on a public access terminal cannot be downloaded, and the printing availability is dependent upon how a court has set up where their printers are located. Clerks currently and will continue to review and redact pre-July 1st, 2023 documents before they print or give a copy to a person using the public access terminal. Currently, public access to documents can be found 2 ways. One, you have the public access terminal at each court location statewide. You can go to any courthouse in the state and review any public case with any public document statewide. Additionally, certain documents are available remotely through CaseNet. Those include liens on real estate pursuant to Chapter 429, final civil judgments, except post-conviction proceedings and domestic relations are not available remotely. And you can also get probate orders and decrees serving as judgments remotely. Beginning July 1st, 2023, all public documents that are filed on or after that effective date that would be available at a public access terminal will now be available remotely. Again, only prospective documents will be available at the public, available to the public remotely, but all documents will be available on the public access terminal. Expanded remote public access implementation will be done in a phased-in approach. beginning July 1st, 2023. The Missouri Court Automation Committee has approved a rollout that will begin on July 1st and will continue until all circuits and courts in the state are implemented. Those courts will be implemented in groups until all courts are implemented. You will be able to find the implementation schedule on the courts and the bar's website when it's finalized. When implementation begins, it does not change the fact that certain documents may be subject to orders in a particular case, a statute, or a court rule that makes them confidential. And also, the access to the remote public access may be suspended by the state court's administrator if remote public access proves to be disruptive to the statewide case automation system or court operations. Suspension will be in place until the problem is remedied. So how are confidential records managed by the court? Default security levels are assigned at both the case and the document security level. Those security levels have been determined by the State Judicial Records Committee, and those are applied automatically by the system when accepted by the clerk. The security level on a specific case or document may be raised or lowered, but that must be done by a written court order identifying the reasons for such change. The statewide court automation system does not have the capability to automatically redact documents. That requirement will be on the filer of the document. As I mentioned, security is set by case, document, and by data elements within a document. Case level security is the highest. When a case is considered confidential, all documents in the case are confidential, and access is limited to attorneys of record and to parties in the case. Whereas document level security is done more discreetly. You can have a public case that has confidential documents. Think of a parenting plan that is filed in a dissolution. The parenting plan is considered a confidential document while the dissolution is a public case. The third way that confidential records can be managed is by actually discrete data elements within a document. That may be the social security number, a date of birth, or other information like that. As I mentioned, the case management system does not have the ability to automatically redact those documents. That responsibility will be on the filer. I'm going to briefly review the case and document security levels that the statewide case management system uses. The case level security levels are used with case level securities 1 through 9. Security levels 1 and 2 are considered public or partially public. Those would include all of your public cases and then also the paternity cases once a judgment has been entered. Levels 3 and 4 are considered confidential, and those are only available to attorneys of record and to court staff. That would include your pending paternity cases, your dismissed criminal cases after an SIS has been successfully completed. Level 4 would include your juvenile cases, mental health, or treatment court cases. Level 5 is considered a confidential level, and that is sealed with attorney of record access. That can only be seen by the attorneys of record on the case or selected court staff. Level 6 confidentiality is considered sealed, court access only. Level 7 is not used currently. Level 8 is a confidential security level, and that is used only for those cases entered in error which are unable to be deleted from the statewide case management system. Security level of 9 is for those confidential cases that have been expunged. Case level, those are the case level securities. Document level security is the same, except it is just uses security levels 1 through 6. You can find an example of how the security levels display on this slide. When you're in File Viewer, you can see a padlock next to a document that is considered confidential. If there's a little number on it, that corresponds with the security level that the case management system has assigned to that document. Next, Judge Bates is going to cover the redaction requirements under the new rules.
Thank you, Kathy. These redaction requirements are necessary now that the Missouri Supreme Court has decided to allow public documents to be remotely accessible. And by remotely, we mean you can log on at home on your computer, look at CaseNet, and actually see documents. One of the big changes in remote access is that it removes an earlier practical obscurity to documents that were filed but were not remotely accessible. It was very common to file all kinds of documents at the courthouse or even in CaseNet, but if no one can look at them, there's very little likelihood that any confidential information contained therein could cause any harm to anyone. With new expanded remote access, that danger is heightened to a large degree. And so the Supreme Court has recognized that and is implementing redaction requirements to try to protect litigants from information that is confidential from being shared on the internet with folks that shouldn't be looking at it. So they've done that by amending Court Operating Rule 2.02c, and then also with new rules 1910 in the criminal context, 55.025 in the civil context, and 84.015 in the appellate context. All of these are essentially identical, and they all become effective on July 1st, 2023. So those rules and Court Operating Rule 2.02 contain the essentials of the Supreme Court's redaction requirements. So let's focus now for the rest of my part of this presentation on these questions. Who's going to be doing the redacting? What are you redacting? And how are you doing it? Trying to apply these new rules. So whose job is it? Kathy's already told you that. For all documents offered for filing in any court, the responsibility for redacting confidential information rests solely with the counsel, party, or other person filing the document. So if you are the filer, it's your duty to redact the document appropriately. Most importantly, courts and clerks will not review each case document to ensure compliance and will not refuse to accept or file a document if there's inadequate redaction. So this is on the filer, and the clerks and the courts will not be able to help you. This rule does apply to court-generated records as well, but judges and judicial staff are not required to certify compliance with redaction requirements as other filers are. What has to be removed from the documents? The rule is very broad. Information that is confidential pursuant to statute, court rule or order or other law has to be redacted. But what does that mean? The Supreme Court has given us a non-exclusive list. They're going to tell you some of the things that they think should be redacted. They're not going to tell you all the things that ought to be redacted, but here's some of the things that they have specifically enumerated in the rule that need to be redacted from your filings. Number one, Social Security numbers. We all understand the danger there if those are out in the clear. Even driver's license numbers, state ID numbers, taxpayer ID numbers, and passport numbers are all considered confidential and have to be redacted. Another problem with court records is that they often deal with financial institutions, so account numbers, credit or debit card numbers, personal identification numbers or passwords used to secure those accounts, all of that is considered to be confidential information that is subject to redaction. This may be an area that is less familiar to a lot of you, and that is names, addresses, and contact information of informants, victims to crimes, witnesses, and persons protected under orders of protection or restraining orders, all of that is considered to be confidential information that must be redacted. Another one that is not going to necessarily jump out at you is dates of birth. We're not supposed to put full dates of birth for anyone, and the problem is simple. That is one part of the information that scammers and fakers can use to obtain information about you and build a false identity, so we don't want full dates of birth. Another problem that isn't intuitive is names of individuals known to be minors. So anyone who is a minor, who's named in some document that you're filing with the court, you're supposed to redact their names. Case numbers of confidential, expunged, or sealed records is another recognized category, but one of very little usage, I would expect. And then here's the large caveat, and this is a huge one, and you need to be really alert to this whenever you're getting ready to prepare things. Filers, and this is directly from the Supreme Court's Rule 2.02, filers should also exercise caution when filing documents that include medical records, employment history, financial records, proprietary information, or trade secrets. And that is an enormous category, and it will require lots and lots of thought as you are filing cases and documents within cases that may deal with these subjects. What has to be redacted? So here are some questions and a couple of observations that we'd like to share with you. Does the redaction rule require that the listed types of information be redacted? Yes, it does. It absolutely says explicitly in these rules that this is the kind of information that is confidential and must be redacted. Is the listing in the redaction rules a safe harbor? It's hard to say, because the Supreme Court is very interested in protecting confidential information, and the list is explicitly described as including but not limited to these number of things. And so you'll have to use your own expertise and do a case-by-case analysis of whether there's something that is or isn't required to be redacted. One suggestion that has been made is that any confidential information that's not legally required to be included in your filing should be omitted. It's just the safest practice. And so it may be different than what we've done in the past, but this is the new normal and may require a change of those old procedures to leave out anything that is not essential. And may required or necessary non-confidential information, which is nevertheless considered personal information, be redacted? We don't know. My suggestion is, especially at the beginning, if I were an attorney filing documents, I would rather be overly cautious than underly cautious. So if I had a question, if I'm not sure if it's personal information that ought to be treated as confidential, I would redact it. And the judge is always the arbiter of that. If someone else complains and says that information shouldn't be redacted, you can have a hearing on it, get a ruling on it, and then the judge has made a decision, and so it's not your call anymore. So a couple of more observations. These rules are different than Court Operating Rule 2.05. That applies to some other specific kinds of information. One of those is very important. We see it a lot in our Court of Appeals documents, and that is Section 559.226. We are not required to expunge or redact Social Security numbers or personal information that appears in court cases. So lawyers and other filers will need to decide what information should be redacted in a document. And remember, that's the major takeaway from all of this. You are the filer. You need to be very careful in deciding what needs to be excluded or redacted from that document. So here are some examples of sources regarding confidentiality, because the Supreme Court has described it in those terms, but what sorts of things actually are considered confidential? Well, here's an example. Section 509.520 requires that certain information be included in particular court pleadings. So you may be required legally to put it in there, but you may be required to redact it because it's confidential. As I mentioned, this 559.226 Anything that would lead to the identity or location of a Chapter 566 sex crime, domestic assault, or stalking victim. And so that's not just the information about them, but even things that lead to their location. You need to be extremely careful about that because all of that is considered to be confidential. In criminal cases, the prosecutor may redact information in discovery responses in criminal proceedings. So that's another explicit example of how one party may have the ability to redact things that is not made accessible to other people, or at least not at that stage of the proceeding. And that Rule 2511B, you can also get protective orders for redaction in criminal cases. The Missouri Bar is developing and will continue to update an expanded list of potential sources of confidentiality, but they are vast, and so that may be a long-term project. Here's a link to the Missouri Bar website with as much information as there is to date to help you in making those kinds of decisions. And these are just for illustration purposes only. It's not a comprehensive list. I don't know of anyone who has a comprehensive list at this juncture, and we may never have one. We may be continually adding to it. So how is redaction to be done? Let's talk about the manner of redaction. The rule requires that all redactions shall be done in a manner that makes it clear that information has been redacted. So for example, if you had in your document, John Doe's date of birth is June 1, 2007. If you redacted pursuant to this rule, you would strike out the name and the actual date of birth. So you've made it clear that identity and date of birth, and the reason this particular one is chosen, this person would be a minor. And so their name cannot be displayed and their date of birth cannot be displayed. So when you are redacting, the rule also wants you to provide the other side with a generic description of what it is that you have cut out so that it's not just a blank. So for example, this redaction would be, the first one would be child's name, child meaning minor, and then check the second box would be child one's date of birth. So that's a generic description of the stuff that has been omitted from the redacted copy of the document. Then you have to provide the redacted information to the court and to your opponent in the lawsuit. So when you redact information from a document that's offered for filing, you also have to contemporaneously file a confidential redacted information filing sheet. We refer to those by the term CRIFs, and it does one of two things. So it either provides, and by provides, it has attached to it an unredacted version of the document, or it sets out the information that was redacted from the document and explains either where in the document it was taken from or using generic descriptors to describe what it was, and then to reference that, and then you actually have to put the redacted information into the CRIFs. When you're working on these, and these will need to be used immediately starting on July 1st, 2023, the CRIFs and any attachments are assigned a default document security level of 3, which means that it is not publicly accessible remotely. And it would not be viewable at a public access terminal either, because the security level of the document is high enough that it's not publicly available. The State Judicial Records Committee, and I'm a member of that committee, has approved a CRIFs form for each type of compliance. The first version of that, attachment of the entire document, is still being developed. We have approved the other kind, which is kind of the fill-in-the-blank sort of form. And just to give you an idea of what that would look like, here's a CRIFs form for a civil action, and so you put down who you are, then you put down the redacted information identifier, and using our prior example, it would be child's name, and then you would put the redacted information, John Doe. Then the next one would be child one's date of birth, and then you'd put June 1, 2007. So that's how you'd fill that out. We've done these for both civil and criminal cases. And then the one with just the checkbox is still being developed, but it will be released before July 1, 2023. The next thing I'd like to talk about is the requirement in the rule to certify compliance. How is that done? All filers, except judges and judicial court staff, shall affirmatively certify compliance with the redaction requirements in the applicable rule when a document is filed. So the onus is on the filer to certify. Certification is accomplished by e-filers through an automated process that is part of the e-filing system for its authorized users. Essentially, it's a checkbox that basically says, I hereby certify that I've done all the required redaction to this document. If you don't check that box, you will not be permitted to file that document through the e-filing system. And that form and that checkbox will be part of the e-filing process. So if you don't, as I mentioned, if you don't check the box, you won't be permitted to file it. For folks who are not authorized users of the e-filing system, and for that it would be pro se folks that are not eligible at this point at least to use the e-filing system, they have to certify compliance using a paper form that is attached to the document or appended to the document itself. And for the clerk's benefit, this rule does not require that they monitor or provide oversight or check for compliance for pro se filers. If that form is missing or they refuse to provide it or sign it, the clerk still has to accept the document and file the document even if it's non-compliant. And so with that, I'll turn this over to Melinda, and she will talk about ethical considerations.
Thank you very much. Let's go ahead and get started with an overview of the ethical considerations we have in this new context of remote public access. So these are some of the rules that come to mind immediately when we're talking about remote public access and the ethics considerations. I just want to start out by saying there's really nothing new about these specific requirements. These amendments to the court operating rules, as far as the ethics responsibilities, you already have these ethics responsibilities. What is different about this is that there's this heightened level of awareness because there's this heightened access. Now, instead of members of the public needing to go to the public access terminals at the courthouse or something along that line, or go directly to the clerk's office, they can actually get these on their own computers, on their laptops, cell phones, etc. So you couple that with the Track This Case feature that CaseNet already has, and that can lead to some fairly instantaneous access. As I said, you already have the ethical responsibilities out there and the legal court operating rule responsibilities to redact and to do so properly. But let's take a look at just a bit of a refresher as to these ethics responsibilities as you hone your practices and procedures in advance of July 1. So this really is an ethics issue before it would ever get to the point of being a disciplinary issue. The specific rules start with the rule of competence, Rule 4-1.1, and can go all the way up to misconduct under Rule 4-8.4. So let's take a look at these rules a little bit more in depth. So the first rule is that rule of competence, Rule 4-1.1. It's a very simple rule. It just says that a lawyer shall provide competent representation to a client, and that competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for that representation. There is a comment number 6, on maintaining competence that includes that you should maintain your requisite knowledge and skill, and that you should keep abreast of changes in the law and its practice, as you're doing today by taking this CLE program. And it also says including the benefits and risks associated with relevant technology. And this really does become a technology competence question at this particular point, because you need to make sure that you're technically competent to do these redactions and that you're not solely relying on support staff to do so. and that you know that when you do these redactions, that the information is actually properly redacted and can't be removed and someone could still access that information, etc. So how do you do that? How do you become tech competent? First and foremost, take some CLEs. There's a ton of legal tech articles out there. There's computer training courses. You can consult with an IT professional, a computer training professional. You can do some self-study. There's a number of podcasts out there, blogs, etc. There's a lot of great resources out there available for you to build up your tech competence. And specifically in this context, you need to know how to properly redact documents, figure out what software you're going to use to do so, make sure that you're cleanly scrubbing your documents, removing all metadata from documents, etc., and then also complying with these court operating rules as to what your documents are going to have in their filings. I do just want to give an example of a case out of Oklahoma. It's a disciplinary case. As I said, this is really an ethics issue before it would ever become a disciplinary issue. There's a case, Oklahoma Bar Association versus Oliver. The citation to that is 369 Pacific 3rd, 1074, and it's a 2016 case. And that Oklahoma lawyer was publicly censured in 2016. It was a reciprocal discipline case from the U.S. Bankruptcy Court from the Western District of Oklahoma. That lawyer was suspended for failure to file documents in a manner that was compatible with the applicable rules. And in that case, it was an e-filing system. And so when the Oklahoma Bar was looking at reciprocal discipline for this particular individual, the lawyer fully acknowledged that his problems with the bankruptcy court were caused by his lack of expertise in computer skills and his frustration with trying to meet the federal court's expectations with electronic pleading requirements. The Supreme Court of Oklahoma, in issuing its order of public censure of the lawyer, encouraged this lawyer to continue to improve his computer skills, or better, to hire an adept administrative assistant to do his pleadings. And certainly getting good support staff and training support staff is something that we will talk about, but that's not going to be a substitute for the lawyer's duty of competence under our Rule 4-1.1. So let's move on to, I think, the next most important rule when it comes to your ethics responsibilities, and that is confidentiality of information, because what we're really talking about here is your client's confidential information. So under Rule 4-1.6a, we all know that you have the obligation to hold your client's confidences and that you are prohibited from revealing information relating to the representation of the client unless the client has given informed consent or you meet one of the exceptions of this rule. I want you to pay particular attention to paragraph C of this rule. That provides that a lawyer shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to information relating to the representation of the client. So certainly this is your responsibility because you owe this duty of confidentiality, and the whole idea is to prevent the inadvertent or unauthorized disclosure or unauthorized access to this information when you're filing your pleadings and making sure that they are properly redacted in accordance with the requirements by rule or substantive law. This is your responsibility. It's not up to the clerk or to the court itself. So when you're submitting these redacted documents, you need to do so in a manner that's preserving confidentiality and preventing the revelation of these redacted materials, even in the metadata of the document itself. So everything's properly scrubbed before it's being submitted to the court. And make sure that it's sanitized as well. I want you to direct your attention to comments 15 and 16 of that rule that also provide factors for you to consider when you're transmitting your confidential client information and the sensitivity levels that you're going to have to that. It does note specifically in those provisions in comments 15 and 16 that a breach of this confidentiality under Rule 4-1.6c could result in a violation of state and federal laws when it comes to data privacy, and those laws may apply as well, and that could trigger some notification requirements on your part. So it is very important that you make sure that you are in compliance with that duty of confidentiality under 4-1.6 when you're doing your redactions for these filings. The next rule I want to take you to is just Rule 4-3.4, and this is a very brief rule as to its applicability here. It says that a lawyer shall not knowingly disobey an obligation under the rules of the tribunal except for an open refusal based on an assertion that no valid obligation exists, and that's certainly not the case in this point. Comment number 4 to this rule specifically states, though, that lawyers have an ethical duty to comply with court orders in both their professional and personal capacities. So this is an obligation of the court, it is a court rule, and so you need to make sure that you are competent and following these rules as well when it comes to your e-filing and your redactions. This next rule on trial publicity, I cited this as a consideration because it prohibits a lawyer from making an extrajudicial statement or public communication that will have a substantial likelihood of materially prejudicing the adjudicative proceeding. It may be possible that in the event of an improperly filed document, improperly redacted document, it could trigger the standard under Rule 4-3.6. So this is just another example of something for you to consider as an ethics obligation. Then moving on, you really need to consider your responsibilities over non-lawyer assistants. As was suggested in that Oklahoma case, non-lawyer assistants can really be a great asset to you, but they can also be a really great liability if they're not properly supervised and trained. Per Rule 4-5.3 A and B, partners or others who have managerial or supervisory authority within a law firm are required to make reasonable efforts to ensure that non-lawyer assistants are conducting themselves in a manner that's compatible with the professional obligations of the lawyer. In this particular context, what we're talking about is proper training as to confidentiality of information and technical competence too. So if you have these non-lawyer assistants helping you redacting pleadings for e-filings and filling out these forms for your review, that you are taking that supervisory responsibility and that they know what they're doing, and that you are making sure that everything is compatible with your professional obligations. Because if you look at the next part of this rule, you as lawyers are responsible for training and supervising these non-lawyer assistants. And if you tell a non-lawyer assistant to go e-file a document on your behalf, you're responsible for that filing. That's going to count as ordering or ratifying that particular non-lawyer assistant's conduct for the purposes of Rule 4-5.3c, where the lawyer is responsible for that conduct. So when you review these documents, you need to make sure that you are doing so and that everything is in accordance with the proper rules before they're actually being filed. And if there is a problem with the filing, Rule 4-5.3c2 discusses how you can mitigate consequences to the clients. And I've given you some citations to some informal ethics advisory opinions that we have on various scenarios wherein there's been some kind of breach of client data or loss of client data and the notification requirements that attach to those. And then finally, it could be considered to be professional misconduct under Rule 4-8.4 if you violate or attempt to violate the rules through the acts of another or engage in conduct that's prejudicial to the administration of justice. And so certainly failure to properly follow the redaction requirements and the court operating rules in this context could give rise ultimately to a misconduct allegation as well. So at this point in time, I just want to leave you with some ethics resources. If you're not familiar with my office, you can call and receive an ethics informal advisory opinion. So if you have a question about complying with your ethics responsibilities here, you're welcome to give me a call. I'm happy to discuss those with you. I can't discuss the mechanics of all of the e-filing system itself, but I can certainly help you with your ethics requirements that we've discussed here today. So here's a link to my office website.